बहस आपने जो पूरी अपनी बहस शुरू की है वो आपने किसी और बेसिस पे शुरू किया। आप अपने आर्गुमेंट्स करते हैं तो ये सारे मसले आपके लिए खड़े नहीं होते। But sometimes it is not very easy to give a yes no answer. It was like the young on a lighter note, माहौल भी जरा ठंडा रखते हैं। अच्छी बात है। On a lighter note, a lawyer was battering a lady during cross-examination. No, sorry, the husband representing the lady, and he said, "Have you stopped beating your wife? Answer yes or no." So keep it things light and move ahead.
So I'll just conclude my this submission by saying that the 1980 rules or the 1956 rules, though existing laws when the Constitution came in, but saying that they were the law within the meaning of Article 191 would be a contradiction.
Okay, can I ask a question? ये एक सवाल सुन लें कि आप ये कह रहे हैं कि वैसे तो the rules are law, but for the purposes of 191 they are not law. Now, wherever the word law has been used, what principle of interpretation will be applied to see whether these rules or any other rules will be applicable there in the term law or not? The reason I ask this question is that the first day, my question to you was that if subject to the Constitution and the law meant law just an act of Parliament to the exclusion of everything else, then maybe the word law was not the right word. So when we look at the word law, we have to read something more than just an act of Parliament. So the act of Parliament is there, but other things are there. Now you are saying उसमें से आप ये rules निकाल लें because यहाँ rules नहीं apply होंगे. Then in some other provision rules डाल दें because वहाँ rules apply होंगे. So there doesn't appear to be any principle of law that one is following on the basis of which one would determine where to use what part of law.
Isme learned Attorney General, since this discussion is in the context of Article 191, can we construe Article 191 that the rules may be made by the Supreme Court subject to the rules that it will make? This is the simple question. You see, it automatically excludes the rules that will be made.
My Lord Justice,
because it is in the context of Article 191.
एक बात AG साहब और भी है, what I understand from the questions of the learned colleagues, that is subject to the Constitution and law. Obviously, the Supreme Court may make the rules. Once the rules have been framed, and maybe this may be included in the definition of law, but whether there is any sunset clause after making rules by the Supreme Court, the word law has become redundant. Is the purpose then? Yes. If we are talking on it, then once the Supreme Court has made the rules, that has become the end of the story, and they cannot make further rules.
Redundancy.
And the redundancy attribute हो रही है ना, अगर हम उसको करते हैं कि Supreme Court rule बना सकता है. Supreme Court has made up the rules. Then what is the purpose of the law used in the Article 191? Because there is no sunset clause. After making rules, obviously it will be a sunset clause for that. जैसे आपने नीचे पढ़ा है ना कि वो हाई कोर्ट के लिए उसकी प्रेसिडेंट साहब नहीं करते तो वहाँ सनसेट क्लॉज है, unless such time the president make the rules.
So as I see it, the word law is evergreen in 191, and secondly, it might entail other instruments. But what I'm concerned with right now is the Act of the Parliament is also there, and that is enough for me to go forward.
Yes. So
are you going to answer my question? क्योंकि वो तो रह गया.
According to you,
I owe an answer to a lady.
According to you, once the rules have been framed, in exercise of constitutional jurisdiction that 191 confers, they are law. Number one. Number two, because of the language of 191, it is an exclusive power given to the Supreme Court rules.
Where does the
Subject to the Supreme Court may make framed rules.
Yes.
So the Supreme Court framed rules.
And subject to the law and the
So
Constitution.
what you're saying is, once this law has been made or framed by the Supreme Court, can a subsequent act of the Parliament trump it? or modify it or render it redundant.
My lord, there is no fetter, there is no restriction under 191 on Parliament's power to make any amendments, barring one, which is that it should not in any way undermine independence of judiciary.
वो तो standard test
वो
लगेगा ना,
standard
all the
test है,
first-
उसके अलावा there is nothing in the language of 191.
अगर मैं आपकी बात समझ
So,
पाया
if you invert the
Ladyship, my lord is not letting
Equation.
me answer the question. So.
if you invert the equation, the same thing can be done by the Parliament, the same thing can be done by the Supreme Court. Both can make the law as far as practice and procedure is concerned. So you say there is no fetter on the power of the Parliament to amend the rules that the Supreme Court makes.
Yes.
So if you invert the equation, then there is no fetter on the power of the Supreme Court to amend the law that the Parliament makes.
But then it's
Subject
Subject to what?
Law.
Subject to law,
the
तो
rules of
law वही
Supreme
है ना,
Court,
आप कह रहे हैं ये भी
I
law
don't
है,
follow.
वो भी law है.
No.
So then there is
नहीं,
an
नहीं,
interaction
नहीं.
of two laws.
The interaction.
Or a conflict of two laws.
There is no, there can't be interaction to two laws. In that broader sense, Constitution also is a positive law. We can't possibly say
so
that.
then the parliament that makes law that you're saying subsequent.
Parliament is the lawgiver, my lord. Let's acknowledge it.
Hold on. It stands on a higher pedestal.
Parliament is the lawgiver.
ये बताइए
जो सेपरेशन के ऊपर जब बात करनी है, मैं वहां तक अगर पहुंचा तो यही बात करूंगा कि
Learned Attorney General, ये बताइए
अगर ये आपका आर्गुमेंट मान लिया जाए तो ये बता दें कि 191 का मकसद क्या था?
Learned Attorney General, ये बताइए, if under the obligation under the convention, the Parliament makes a law that all jail appeals shall be fixed within 1 week from the day they are presented, will they not prevail over any of the rules made by the Supreme Court?
Yes.
And those rules will then be subject to this law.
yes, that's right, my lord.
Mr.
And
Attorney
independence
General,
of judiciary is not
And
affected.
independence of
Mr.
judiciary is
Attorney
not
General,
getting affected by this. Access of
Mr.
justice is
Attorney
being
General,
advised.
if the argument is accepted in toto, then what was the fun to insert this 191, Article 119 in the Constitution?
I didn't get the question, my lord.
My question is that what was the fun to insert 191 in the Constitution if it was not the intent of the legislator that the authority has been given to the Supreme Court to frame rules?
Yes, the authority has been given, but with a preface, with something which it is subject to, which is the Constitution
It
and the law.
doesn't mean anything. If it was
That's
exclusive
why
within the
the
domain of the
argument-
legislator, then this 191, that is of no use.
How so? I didn't. I still
What is
haven't
the
gotten
purpose
question.
of what is the purpose of making these rules?
But,
To give effect to the Constitution and law.
and to have the court function, and of course, that's the purpose.
Because the Constitution and law is not so exhaustive. That's why rules are framed to give effect to the act and the Constitution.
May I answer the question first?
Your Ladyship, the term law as used in the Constitution, and as it has, you have noticed, it has been used at various instances. In addition to as an act of parliament, that term specifically act of parliament has been used. We will look at the provision, and from the provision we'll call out what that term then implies, in the sense that, as I've submitted, which source of law is it referring to, or which source of law does it capture? Whether it is exclusively, or in the context of that provision, be termed as an act of the appropriate legislature, or would it also include how the courts have expounded that law, and that law is also applied insofar as that proceeding is concerned. But for the purposes of Article 191, my respectful submission is that an act of parliament as law cannot be excluded.
I accept your argument that it cannot be excluded. The question is that if it can't be just an act of parliament, it has to be something more. So when you argue on the strength that just look at it as an act of parliament, because it's included, it's enough to proceed forward and say, yahan se competence dikhte. That's where I have difficulty. That when it's just an act of parliament, then there is a definite word used that by an act of parliament. Here the word is law, so it will clearly mean more than just an act of parliament. Why are you reading it to the exclusion of everything else?
So let's...
And Mr. Attorney General, I see it this way that we are reading it as an exclusion to the other thing because the question is of competence.
Yes.
So I'm not concerned about the other instruments. I'm concerned about the main instrument, that's the act of the parliament.
So, and we'd be concerned perhaps with the other instrument, if I may just complete, with the other instrument, if there is any conflict between this instrument and some other principle which the court may have laid down, and I'll address that.
If I may have a clarification, if I understand you correctly, what you're saying is the rule-making power conferred on the Supreme Court by Article 191 is law, but the source of law in respect of the word used over there, that's the source of that law is not the rule-making power. That law, the source of that law, according to you, is an act of parliament. So that's the distinction that you draw, but you recognize, you accept that the rule-making power conferred by the Constitution on the Supreme Court also creates law. The source of that law, the rules, is the Supreme Court, but the source of the law, the word as used in the preceding part, the source of that law cannot be the rule-making power. It is somewhere else, wherever that may be, but it is somewhere. I have understood.
Yes, that's right. My Lord, if I may now address the second part of it, the second question, which my
Forgotten the second question. You've forgotten the second question.
No, I have the convention bit. The convention bit, because some interesting question had arisen.
That was question number 1. As according to me, question number 2 was relating to 56 rules.
Yeah.
56 rules have already. जी, वो इस सारी conversation के अंदर back and forth.
You're on the convention.
ये 56 के rules कौन से provision के तहत बने थे Constitution?
My Lord, 56 के rules
ने बनाए, the President hereby make the following rules.
Third schedule of 1956 Constitution उस वक्त बने थे sir.
हम नहीं, मगर इसमें लिखा हुआ है rule making powers with the approval of the President.
जी, जो 1956 के rules हैं. Because उस
वक्त ये जो 1980 के या 191 के तहत
जी 191 के नीचे बने. उस वक्त 1956 के Constitution में approval required थी President की
जो last rules बने हैं वो 80 में बने हैं ना हमारे. तो इसका मतलब यह है कि legislator has not performed its duty for 43 years.
नहीं, ड्यूटी नहीं परफॉर्म की, उन्होंने आपको कहा कि आप बनाते रहिए, ठीक बना रहे थे.
अब उनको ख्याल आ गया.
ठीक बने हुए थे तो उन्होंने कहा कि ठीक चलते रहे. अभी आके उन्होंने कहा कि कुछ थोड़ी सी इंटरवेंशन की जरूरत आ गई है.
मतलब आपका कहना ये कि जब तक सुप्रीम कोर्ट सही चल रही थी तो उन्होंने
मैंने तो फर्स्ट हियरिंग पे आपको कहा था कि अगर ये 70,000 पे पेंडेंसी चली गई तो शायद एक और लॉ की जरूरत पड़ जाए. अगर ये 20,000 पे आ जाए तो वो कहेंगे बैक ऑफ, पीपल विल नॉट अप्रूव ऑफ इट. हमने 5 साल बाद लोगों के पास जाना होता है, लोग हमें नहीं अप्रूव करेंगे.
जरा प्लीज आए ना, अपने बिल को जरा देखें.
वो रिकॉर्ड लाए हैं आप, जो कितने लोग थे, कितनी देर इसकी बहस हुई, कितने लोगों ने.
वो रिकॉर्ड पे आगे ही नहीं है, वो वेबसाइट पे भी थी, वो मैंने वैसे प्रोवाइड.
आप जब आप बात कर रहे हैं पार्लियामेंट की, तो पार्लियामेंट में एक बिल आया है, बिल के साथ स्टेटमेंट ऑफ ऑब्जेक्ट्स और रीजंस उन्होंने दी हैं. जो आप कह रहे हैं कि सुप्रीम कोर्ट में शॉर्ट कमिंग्स थी, लेट मी बी पोलाइट, शॉर्ट कमिंग्स थी, एक्सरसाइज ऑफ डिस्क्रेशन, एक्सरसाइज ऑफ ज्यूरिसडिक्शन, जिसके बेस पे आपने ये लॉ इंट्रोड्यूस किया. सो देयर इज अ स्टेटमेंट ऑफ ऑब्जेक्ट्स एंड रीजंस.